The delivery of judgment.
Petition is dismissed. MFA 142 of 19 is 82 of 19. Judgment and order stands modified. The amount is recalculated. An amount of rupees 966.
So for statutory deposit, allowed to withdraw.
Was that in the separate order?
Affiliates. Item number 11. I have taken for 11.
Seven. Prayer of your for for
Yes, whatever.
you are appearing for
Or the
petitioner.
petitioner.
Matter again on
Developers.
Department as an informant. Additional AG, Mr. Accommodation. Have informed the other side as well.
3031.
My lord, in item number 1, I am for respondent. All right, my lord, as per.
So I beg to mention item number 20 from Delhi list, my lord.
0.
Available, item 20. But, yeah, the date, my lord.
Monday.
Like. You may be continue as again. Please.
Is your lordship. Your lord. PV petition lordship. Friday lordship.
View petition.
Honorable
Monday.
Friday lordship.
No, it cannot be.
Lordship. Much obliged.
Lordship, I beg to mention item number 32. I'm seeking on the ground that my senior having some personal have taken the consent from Lordship may it be fixed.
32.
Yes, your Lordship.
You're for the respondent.
I am for the petitioner.
Second consent.
Much obliged.
Please, your lordship. Consent with the other side, lordship. I beg to mention item number 15, lordship. And on behalf of the CM Speeches Residential, lordship. The criminal petition, lordship, crossing of a FIR.
Yes. What do you want?
After 10 days, lordship. Time for the
Respondent.
special people, lordship.
It.
Lordship, I am appearing on behalf of the petitioner's side on item number 14. My senior Darakula could not appear today due to some personal inconvenience. With the consent of the other side, we are praying for another date.
Vivification.
Please, your Lordship. Lordship, with the consent of the other side, I beg to mention item number 29, Lordship. I pray for Passover for the day, Lordship.
Two 2015 matter.
Lordship, I have another prayer, Lordship. Lordship, can the copy be provided to us here, Lordship? The copy of the petition. I'm for respondent number 2, Lordship. But we have could not trace out the petition, copy of the petition. So, kindly allow us to take a
For
xerox of the
certificate
petition.
copy. Okay.
Yes, Lordship.
I've listed Lordship.
A little louder, please. The mic
I
on.
beg to mention for the
Okay.
Yesterday, item number which? One. Yesterday's list, item.
Following, what is it? There must have been passed in that. File the memo then. Withdraw then, let it be listed. Yes,
Item number
is with 26.
26.
Have to obtain consent of
Is that is the
for 26 also. Let it come up.
Yes, your Lordship.
I beg to mention item number 41 and 42 from the. I'm praying for adjournment for the day on ground that my senior is due to some personal difficulties. My senior on
41 and 42.
worship another prayer. May the matter be on the last week of April.
Last week of April.
Your Lordship, the conducting council is on Passover for the time being.
Let him come and have the certificate.
wait, please, your Lordship.
CD. Call CD. Fix it.
Published.
date this incident?
Wait, please, your Lordship. Kindly, madam. Have a estimation, you can act.
Behalf of SC Viswas, adjournment has already been taken in other items, so how can we pass it over for some time now?
And C, Lordship.
May please, Your Lordship. CD may be called for, my lord, and it may be given because, my lord, section 36 was not while arresting the petitioner, my lord.
He has to come anyway after all.
Right.
Well, in this matter, the charge sheet has been submitted, my lord.
Hmm.
And did not aware about the case, my lord. Case was in the year of 2017, my lord. And recently he arrested, my lord. And only she is 19. But for trial, my lord. Charge sheet has already been submitted, my lord, and trial, my lord. Allow him to face the trial, my lord.
Must have the before. Seven is the FIR.
My lord. Is the FIR.
Ali last time.
Allow him face to the court to begin.
You have been in custody since when?
10 of the 10th of March. 10th of
Your
March.
name is Jainal Abedin.
Journal of it.
You were forwarded and then granted bail.
No.
Earlier in 2017.
No, 2017, my lord. A forwarding report is for another accused man. And only, my lord,
Says Mohammed Jainal Abedin.
yes, my lord, journal is not forwarded, my lord. Can you see the forwarding report, my lord?
Yes, I am reading page 16, 15 and 16.
Yes, my lord. Accused Joinal Abedin. I appear for Abdul Jalil.
Lordship.
Abdul Jalil.
Petitioner is Abdul
Say
Jalil.
that,
Yes,
saying it is not for Jainal Abedin.
Abdul Jalil, my lord.
But since only since 11/3.
11th,
Before
my lord.
that, huh?
Actually, he arrested on 10th, my lord.
10/3.
Yes, my
All
lord.
right, scan copy of TCR.
What date may be?
May it lead, Lordship. Call for CD, Lordship, and issued notice to the respondent number 2. What date before the vacation, Lordship?
Saves by speed post tweet.
8 or 9, any date. Seven. Flash.
Lordship,
School
small,
vacation, Lordship.
if possible, your lordship, for Bihu vacation.
Are you alleging any non-compliance with statutory provisions or of just giving another date? Elections are coming. Very doubtful how many CDs will.
Vacation, your lord.
After vacation,
Pleasure. Please, your lordship, my lord. Otherwise, my lord, I would have called for CD, but my lord, in forwarding report, in this case, my lord, the men 5 and 47 has not applied with. That has been clearly mentioned in the forwarding report itself, my lord. Otherwise, my lord, I'll go.
Page?
Yes, my lord. Page number, my lord. Relevant portion is, my lord, 18. This is forwarding report type to be, my lord. Second paragraph further, page 18, my lord. Got it, my lord. Further, notice under section so and so is not complied to the accused person because the accused person released by complying notice under so and so, they will engage in some same crime as well as reasonably it is believed that if a notice under so and so be harm, the accused will not comply with such direction and may expound or and tamper with the evidence, my lord. This is, my lord, clear violation of the, my lord, the mandatory provision as my lord, held by the apex court in Bihan Kumar case, my lord. Otherwise, my lord, I will go for CD, my lord. This is the only, my lord, violation of law, my lord, that attacks the penal provision, my lord. For 35(3), my lord, it is in case of a person not arrested, my lord.
You are on 35(3) only.
Yes, my lord. They said, my lord, no notice whatsoever served upon the accused, my lord, neither to the family members, my lord. Otherwise, my lord, I will go for the CD, my lord. But this is, my lord, a clear violation which vitiates the, my lord, custodial detention, my lord. The accused person is already behind the bar for 50 days.
50.
50 days, my lord.
What is the offense?
So the
cattle,
cattle preservation act, my lord, some Ellis, my lord, meat has been found. About 10 kg, my lord. And that has been sent to forensic, my lord. One of the co-accused has been released on bail, my lord. Anticipatory bail. Only thing, my lord, the mandatory provision, whether they have complied or not. And for any report, my lord, it is clearly stated that they have not complied with the notice.
What law has been violated according to you?
Sir?
What has been violated? Read 35(3).
That is, my lord,
All cases where arrest of a person is not required under subsection 1.
And a person
Where the
is,
police has determined that his arrest is required. So where is the question of issuing him notice?
strictly, my lord. In case of my lord, when person is not arrested, my lord, then my lord, 35(3) has to be complied with, my lord.
Afraid I cannot agree with you.
Short date, my lord, your lordship short date may be given, my lord. Otherwise, 50 days has been completed. And 353 is, my lord,
That is what you should have hammered on.
that is, my lord,
Period of detention instead of your misplaced reliance on 35(3).
that is, my lord.
35(3) is applicable in cases where the police determined that his arrest is not required.
Yes, yes.
Then this notice is to
Yes,
be issued.
I'm
Here police has determined that his arrest is required for this.
yes, yes.
Therefore, there is no necessity of issuing a notice under 35(3). Anyway, 50 days. I'd learn it counsel for the application for. On
3 to 26, my lord. 3 to 26.
this case. If of the is the petitioner is that having the submission of learned counsel accused in the case
Namely, my lord, Habibur Rahman, my lord.
one has been cleared as bail. Order.
My lord,
Order is there.
not annexed, my lord, but I have the case number, my lord.
In
In AB number, my lord.
by the number,
I'll give you.
tell us the date of the order.
Yes, my lord, yes. I have the copy, my lord. I am the place it, my lord.
Is in custody. So shall be
My
released
lord,
on
AB
bail
number, my lord.
50,000 for like amount to the return of the
My lord, I got the case number, my lord, and date, my lord, also.
I shall cooperate.
I got the case number and date also, my lord. AB number. AB number 526/26. Date of order 12/3/26. Highly obliged, my lord. Much obliged.
Disposed.
Apprehending arrest in connection with my lord, Jinjia PS case number 146/25. Lordship will find the FIR at page 11, my lord. The issue is that, my lord, my house was alleged to be, my lord, used by the co-accused, my lord.
The
Lordship will
previous
find-
case.
Kindly, my lord, page 12, my lord. It is annexure B, my lord. The co-accused has prayed for anticipatory bail, my lord. Earlier it was granted, my lord. Thereafter, one was made absolute, my lord. Other two has been rejected, my lord. My lord, here at this stage, my lord, may I pray for similar opportunity to appear before the IO, my lord.
Where are you?
I am, my lord, Amir Hussain, my lord.
Eh?
Amir Hussain, my lord.
Amir.
Amir, my lord. Another case, my lord, it is
Who was granted Ali Hussain.
Ali Hussain was granted, my lord. Abdul
Idris
Hasid
and
Idris
Abdul
was
rejected.
Rejected, my lord.
You are Amir.
I am Amir, my lord.
Let us see the FIR.
Page 11, my lord. May I read, my lord? সন্মান সহকাৰে জনা যে আজি ইংৰাজী 16/12/25 তাৰিখে কোন সূত্ৰে জানিব পৰা মতে পৰা গ'ল যে নিজ বাঘমাৰী গাঁৱৰ মহম্মদ আমিৰ হুছেইন নামৰ লোকজনৰ ঘৰত বহুত দিনৰ পৰা অবৈধভাৱে গৰু কাটি মাংস বিক্ৰী কৰি আহিছে। উক্ত সংক্ৰান্তত মই মাননীয় জিঞ্জিয়া থানাৰ ভাৰপ্ৰাপ্ত আৰক্ষী বিষয়া মহোদয়ৰ নিৰ্দেশ মৰ্মে যাৱতীয় ষ্টাফ সহ নিজ বাঘমাৰী চুটপাম গাঁৱত মহম্মদ আমিৰ হুছেইনৰ ঘৰত তালাচী কৰাত 4টা গৰুৰ ঠেং, এটা গৰুৰ মূৰ, এখন বঠিদা পাই স্থানীয় সাক্ষীৰ সাক্ষাতত জব্দনামা অনুসৰি জব্দ কৰা হয়। যদিও পুলিচ অহাৰ কথা জানিব পাৰি পদকীয়াজন পলাই যায়। প্ৰকাশ থাকে যে উক্ত পদকীয়াজনে অন্য
You are the main accused.
as per
Cows are stolen. Expected that the cows are stolen from other places.
this my lord, FIR does not say that I am involved in the my lord commission of offense, but my house was my lord used, my lord. Kindly, my lord,
Then your house was used and you are not involved in the commission.
notaring my lord using of a house.
Where
is
do you
fine,
stay?
my
In
lord.
America?
Oh my lord, I'm there, my lord. Somebody have my lord put their illegal items in my house, my lord. Maybe, my lord. My lord.
Considering the fact that after perusal of the CD, 2 other co-accused prayer has been rejected already.
View, my lord. Obliged, my lord.
My pleasure, Lordship. Asubadi matter for it.
Kindly pass over, my lord. For timing, my lord. There is a lag, my lord, code number 9.
Please, Lordship, matter may be adjourned for a week, Lordship. I'm on behalf of T.S. Hazarika. He has some personal difficulties. Lordship.
I am for the respondents. Not because they stay right here with this accident case. Ready to argue now.
Week, Lordship.
I am filing
Yes,
objection
yes.
against the
On last date, he has not appeared and filed an objection.
copy of the side sheet, my lord.
They have been granted on only one occasion. Accommodated them this time. The date next week.
Okay, madam, we continue. Obliged.
Yeah,
Can copy is there. ma'am.
after some time.
Charge sheeted matter, Lordship.
No PW is examined.
No examination. 93 days behind bars, Lordship.
6 months.
The FIR is on page 9, Lordship. Page 10 is the relevant portion, Lordship, translated portion.
It might be served.
Subsequently, Lordship. Charges were framed under.
Description is only laceration in sharp.
And there's some accused before.
That has been observed in page 23, charge sheet, Lordship. Was in a love relationship, Lordship, marriage, Lordship, with the girl, Lordship. That has been done in the FIR, Lordship. Subsequently, they marriage to her to a different person. Him to confront.
Days? 20 days behind bar?
93 days, Lordship.
Can copy of TCRS. The allegation for the FIR is altercations had arisen between sides. However, settled. Is an assaulted in forearm and also fracture. Neck. What is the date of arrest?
21/12/2025.
By now has spent 93 days behind bars. Fact that the charge sheet has already been submitted and the detention of the prisoner is not considered. Verifications. He is also a witness.
Postman.
Obliged, Lordship, deeply obliged.
Thank you, Your Lordship. FIR is a page. Arts at page.
Date, my lord. You have an interim, my lord.
Next date of listing.
Awesome. Pleasure.
March. Received. FIR.
Is that is 13, my lord, in Assamese.
What is the statement of the victim?
Statement, my lord.
Punishment for 8.
3 years, extended to আমি দিয়া নাই তেওঁলোকে দিছিলে এইটো কম্প্ৰমাইজ হোৱা বুলি then only we do not there is no mention about it
Yes.
My lord, prior to this FIR lodged by the informant, the informant on 14/11/2025 made a representation to the OC uh, stating that they have already settled the matter amicably, and she has stated certain conditions, and those conditions have been also followed by the accused. After that agreement, the accused never went to the house of the informant, only with a view to malign the image of the accused in the society and also harass the accused. This subsequent FIR, false FIR, has been lost.
Yes, while will he lodge a false FIR?
As FIR, my lord, page 17 in Assamese version. Page 17 in Excerpt 2.
Yes.
Intimation was given by the informant, stating certain grounds that the accused never or nor any state or any other deeds to be done by the accused person after this agreement. Agreement was made before the police station and submitted to the OC. Subsequently, this false affair has been lost. Because he never went to the house of the informant, he did not commit any offense as alleged. And another affair has been lost by the wife of the accused, page number, my lord, 20, on 20/12/2025, stating certain grounds that they have been threatened by the informant when they asked for the loan amount given by them. This is the whole fact. The informant took certain amount of money from the accused, and that money, whenever demands back by the accused, subsequently the informant tries to cause FIR and harass the accused. Considering all aspects, my lord, since there is amicably settled between the parties and the two in the police station concerned, considering all aspects, he
The
may
date
be,
of the settlement?
my lord, 14/11, page number 17, my lord. 14/11/2025. And this FIR has been lost, my present FIR, on 3/1/2026, after nearly 1.5 months.
Now FIR is at 3/1/2026, my lord. Regarding the page 17, my lord, and next registered, my lord, though intimation.
But I'm saying this, after the settlement of 14/11/25,
Lordship,
this FIR has been lodged.
as settlement doesn't work, my lord.
Them, my lord, in between the time,
What
the
is the date of occurrence given?
date of
Is there,
occurrence,
my lord, continuing offense satisfied, with due respect,
a specific date is not given.
he comes to our home without any reason after times, my lord.
Says the last line, girl is being victimized since a month.
Since
Yes.
Deliberately, the date of the first FIR, it has not been annexed. That was the first offense. After that, they reached a settlement, the compromise letter, that is a. Eventually, when that did not work out and the offense then was committed, the second FIR has come up, the present FIR.
Earlier FIR. This is the only FIR which has been registered and against which we came before this honorable. Prior to that, no FIR was registered. Perhaps no FIR was given by the informant.
When the FIR that you have attached.
On what basis compromise was made between the parties, we actually
address the
unaware.
court, address the. Even their FIR is not registered, Your Lord. That is at page 8. And it is their case that there was an FIR. That is at page number 4, para 3.
According to you, government had initially lost the FIR when?
Lordship,
Which they have according to you, which they have not annexed.
Lordship, they have not given any date or annexed.
Where from do we get that you had
It's,
earlier lost an FIR?
Page 4, para 3, Your Lordship.
It was lost on 13/11 because it says, agreement says the FIR lost yesterday. All right, we'll examine the CD.
Matter may be taken up after some time, Your Lordship. He said X in other code, Your Lordship. Obviously.
Your Lordship, I'm praying for withdrawal.
Withdrawal. Well,
They have filed a criminal petition and
your
Yes.
name?
S. Chanda.
S. Chanda, Learned Counsel. Withdrawn.
By appeal, Your Lordship. Tail appeal, my lord.
IA is for
my
what?
lord. Yes. My lord, the conviction was under section 376 and section 4 of POCSO, my lord. 10 years of imprisonment, my lord. Almost half of the period, my lord, he has 4 years, 4 months, my lord.
Objection filed.
Yes, my lord. Almost half of the period gone, my lord. Objection.
The case is pending for 2022 is a jail appeal, my lord. That my lord, IA is of 2025, my lord.
Prayer was with that original appeal, my lord, jail appeal. When in the first order, my lord, the first order, it was reflected, my lord. May be considered, my lord, almost the period, my lord, and
Let it come.
Fine, next week we file.
Next week I will file it, my lord.
Should list the matter. But did it-
Lodged. Notice could not. Not found in that is.
FIR
Annex, page number 16.
Respondent number 2 is this Prasanto Barua. Chief editor, Daily Agrodut.
Yes.
No such person exists. Take steps by Dusty Service. Office is in Gauhati. Learned Council for the as per 20 notice in respect to has been received back. Mark quote such person in this address RTS. It's on the perusal of the FIR that the respondent described as the right, and this in Upahampalok. Good, Dispur. Eight 4730998853. Therefore, directed to F Dusty Service upon the said respondent number 2 and file. Matter again on
Item 20. Preferred by 3 appellants. Now appellants number 2 and 3 may not be IA for suspension of sentence and manner.
Proceed this. I have already undergone years 3 months and sentence is for 5 years. Under section 2B TPS Act.
3 years, 3
3
months.
years, 3 months. 7 days, 1193 days. I was arrested on 17/12/2020.
Had Learned Council and stroke. A to the IA has been preferred seeking since of 5 years RI imposed by the impugned judge 12/4/24 passed by the learned session stroke 2022 will be unto kept. of the sentence. Learned. By instance, dispose.
I have a prayer for the male appeal, my lord, because the appellant number 1, my lord. Somebody else is out and she remains in jail. Still appeal, so I was not able to file an IA also because I have no instruction. Your lordship is pleased to fix a date in April, my lord, because out of 5 years, 3 years and 3 months has gone by. Matter can be heard of and decided, my lord. After being.
In appeal on the prayer of
One more prayer, my lord. I
Hearing.
only have the judgment, my lord. Registry has not given me the copy.
order, the registry. Of the thing.
Is not there, my lord. Because
Memo is not there. Oh, it says-
will appeal by positions, my lord.
that is the trial court records.
I'll put a question. I'm deeply obliged.
To the. Seven.
Same connected, man, are in the
Same
same
date.
date, man. Yes, sir.
May I please, Your Lordship, in this matter, as per last court's order, been received by the Office of the Additional
Court, man, it is awaited.
Submitted by learned counsel for the petitioner that steps have been taken on 5/2/26. Dated 2/2/20. Is for some time to. But
obliged, Lordship.
I will pass them up for a time being, my lord. For time being, my lord, my senior is in next.
मतलब 8, please, Lordship. I have approached this honorable court challenging the order of granting maintenance to the wife particularly, not to the children. Wife is living separately since 2013, and petitioner is a constable and posted at different places. Petitioner left his wife along with his old mother and brother at Swalkusi. During this period, petitioner's wife started relation with his brother and started living with his brother. And ultimately, they are residing in a separate residence constructed by my brother at Swalkusi itself. And my home and the brother's home is separated by wall. Admittedly, they are living separately and they are staying with my brother. She is living with my brother. As per Lordship, the law, I am liable to pay maintenance to my children. I have no objection to that effect. And I have challenged the order of getting maintenance to my. That is my case, Lordship. And as per 125(4), Lordship is aware, when wife is living separately, because adultery is not possible to prove because I cannot take any photographs or I cannot be witness to the adultery. As per judgment of this honorable court, there is no possibility to prove adultery. But I can establish that she is living separately from me and she is living with my brother. I have examined the dependent witness. Village meeting was held, and there is also an agreement, though it is not legally valid, regarding Lordship the separation. And that agreement was executed in presence of the villagers. And she has agreed to live separately, not with me. And if it was forced, she will commit suicide. That is the evidence before the court. Ultimately, Honorable Court, by order dated 26/5/2025, granted maintenance 6,000 to the wife, 2,000 to the daughter Prohibitions, till she married. She already married on 2023. 4,000 to next daughter till her marriage, and 2,000 to son till attain majority. Now, Lordship, separate application has been filed. Next petition that the maintenance given to June Das should be enhanced because he has already attained majority, and he has filed an application, separate application for granting maintenance to the son because he is a student of Royal Global University. So they want maintenance for that son. That is separate petition. I am challenging the order of granting maintenance to the wife. Before going to the relevant provision, portion of the evidence, may I read 125(4). No wife shall be entitled to receive allowance for maintenance or interim maintenance and expenses of proceeding, as the case may be, from her husband under this section if she live in adultery or if without any sufficient reasons she is refused to live with her husband or they are living separately by mutual consent. So my case will be, Lordship, there are earlier 2 cases. One is, Lordship, I have already filed a divorce case before the family court, and she also filed a case under the Domestic Violence Act before the court of CGM at Hajo, additional CGM at Hajo. And Lordship, ultimately, in the DV case, he has agreed that she will come back with me and stay together. Accordingly, an application was filed before the domestic violence court before the domestic violence, and accordingly, she agreed to come back on assurance that I will pay 5,000 rupees per month to her independently, and she will live with me.
but also thereafter she did not come. And thereafter I stopped making payment of rupees 5,000. Thereafter, I have also withdrawn the divorce case, which was pending in the family court because of this agreement. Ultimately, she has approached the family court again, claiming maintenance. May I take your lordship? Page 16. Though it is not legally valid, page 16 is a type copy and Assamese version is page 17. May I read the Assamese portion? সামাজিক প্ৰথাৰে বিবাহ কাৰ্য সম্পাদন হৈছিল আৰু তেতিয়াৰ পৰা প্ৰথম আৰু দ্বিতীয় পক্ষ প্ৰথম পক্ষৰ ঘৰত পত্নী হিচাপে বসবাস কৰিছিল। আজি কিছুদিনৰ পৰা আমাৰ মাজত ভুল বুজাবুজিৰ অশান্তি ঘটাত আমি দুয়ো বিবাহ বিচ্ছেদ কৰিবলৈ স্থিৰ কৰি সমাজৰ মাজত এই বিবাহ বিচ্ছেদ নামত সুস্থ শৰীৰে সুখ জ্ঞানে ইচ্ছাই কাৰো দ্বাৰা কোনো ব্যক্তিৰ জৰিয়তে প্ৰলোভিত ভীতিগ্ৰস্ত নহয় এই বিবাহ বিচ্ছেদ নামত চহী কৰি সম্পাদন কৰিলো। ইয়াত আমাৰ তথ্য আমাৰ অভিভাৱকৰ আমাৰ ৱাৰিছৰ কোনো ওজৰ আপত্তি নাই আৰু কৰিলেও এই বিবাহ বিচ্ছেদ নামৰ পত্ৰমে অগ্ৰাহ্য মান্তি হ'ব। Now, Lordship, during cross-examination regarding this document, he has said that it was obtained by force. Though meeting was held, his signature is not disputed, but she has said it was obtained by force, according to her. She has admitted that the village meeting was held, they have admitted, but it was not by force. Lordship will find DV case at page 21. The joint compromise petition, page 21 in the DV case. May I read para 3? That there was a divorce case pending between the parties before the Principal Judge Family Court, Kamrup, Gauhati, FC case number Iman. The parties were living in the same houses. Respondent in the instant case has recently withdrawn the case and parties are now willing to restitute conjugal right. Respondent, in view of the restitution of conjugal right, will pay area amount of agreed party and the instant case, and he will pay monthly maintenance of rupees 4,000 to the agreed party, and he will deposit the independent bank account, and he will pay the same a check every month. This is the consider that both party has promised that they will create an environment and to at home, and both of them live peacefully and with all mental happiness, and both them shall extend all possible help and cooperation in their good endeavor and shall take care each other. This is the Lordship compromise petition. There is no dispute to that effect. And that has been executed in the court. And ultimately, Lordship, the Honorable Court, Lordship will find page 25. Page 25, the type copy. Seen the joint petition, number Iman, both the parties whereby parties are submitted that both parties have solved their matter under several terms and conditions amongst themselves and pray to withdraw the case. I have both the parties condition considering the prayer of the petition is allowed. So DP case has been withdrawn. Now,
Yes.
may I take the evidence before the DV case? Though it is admitted that there is evidence in the DV case, page 28, that is the evidence of the Bobby Das, page 27. The cross-examination part. Now, Lordship, it is true that the case stated now that I am in my mother's house in the family court counseling was happened. In that counseling, my mother-in-law told that I have been living with Paul Das and both together eat rice.
Reading page.
Page 28. After cross examination, Lordship, next portion. And
Right.
here,
After cross.
after cross, Lordship. Seventh line, it is true.
Yes.
In that counseling, the mother-in-law told that I have been living with Utpal Das and we both together eat rice. I'm reading the relevant portion only, not whole portion. Now, last portion, last but one. It is true that Kantiram kept me with love for about 3 years after marriage. Lordship got it. I will go to Kantiram if court direct me to so. It is true that I have filed false allegation. It is not true that false allegation against Kantiram. Now, Lordship will find page 29, the evidence of Purobidas. She has not examined any witness except her daughter and two daughters and herself. Kindly see page 29. Okay, page 29. Evidence of that is the evidence of Lordship Purobidas' daughter, and she is already married. Cross-examination pass page 30, Lordship.
Yes.
Got it. My father and grandmother together cooked their meal in their said room. Door connecting our room with my father's room was closed by placing a sofa near the door. We are unable to open the door due to sofa. I do not know that such I do not know the village meeting was held in my house over the relationship of mother and father. I do not know that such meeting. My mother stated that she will not stay with my uncle. My father is working in police due to his work. He stayed outside the house for many days. At that time, grandmother, uncle, and mother used to stay in our house. My father used to bear all expenditure of our school and house before the incident. My uncle constructed a house in the backside of our house near the main road. My uncle does not start to live there. My uncle is unmarried. Got it. Thereafter, Lordship, all the villagers, fifth line, all the villagers know that my mother stay with my uncle. My father stated the fact before everyone. I and my brother now stop our father to treat him as father. Both son and the daughter have said that they stop making him father as a father. I do not know the fact that on 2015, the marriage of Sobita Das was held. There is an allegation that I have a love affair with one Sobita Das. And it is admitted that Sobita Das has already got married and staying at Hangrabari. Last portion. My mother used to love my sister and brother, but never loves me. He said, Purobida's eldest sister, she says, father do not love her. Page 31. Last but 4 line. Before the incident, my father loves my mother so much. You got it? Before the incident, my father loves my mother so much. Before the incident, my father give my mother necessary things. Now my mother take herself. And last portion, we live without any deficiency. Because the brother of the petitioner used to support her, and at present in the family court, she has admitted that she is living with my brother in a separate house and there is a separate wall between them. Now, so next order, page 32. Solidas. Page 33. Before this case, my father loves me and my sister and my brother. Before this case, my father loves me and my sister and my brother. Our school fees also paid by our father. My father also loves my uncle. My father and grandmother together eat rice. My grandmother cook. My mother, uncle, and my sister and my brother, I eat together. They separately cook their food and stay separately with my uncle. My uncle had a beautiful house in the backside of our near road. My uncle was unmarried and till now did not move into that house. You've got it. Again, Lordship, before the incident, my father loves my mother. Thirdly, I know that my father do not drink alcohol or smoke cigarette. He's a Lordship, do not speak, though he's a police personnel, he do not drink alcohol, not smoke cigarette. Now, Lordship, all
The
daily
presumption.
necessary are done by my uncle.
There is presumption about policemen.
Generally presumption. Generally the presumption every police officer used to drink. Now, if I will take you to the main case. That is, Lordship, page 51. This is a petition under section 125 before the family court. Page 51. May I take you to page 5311 portion? What is the allegation?
Page 51.
Page 51 is the Lordship, the complaint petition, 125 complaint petition before the principal judge family court.
Now you're taking us to page.
Page 53, Lordship. The respondent husband by profession work in Assam police, and as much most of the time he has to stay outside of the house and has been neglecting the petitioner wife and their children for a long time. The petitioner requested the respondent to take her to his place of posting, but requested he has landed in a DFS. The petitioner is a constable, Lordship. Cannot take his wife to a posting at Bethlehem at Lordship Silchar. And second allegation is that, para 11. Petitioner beg to state that after marriage over a few years, the relation between the parties are very good and cooperative. But as the days pass, respondent has fallen in love with namely Sobita Das, alias Sobi, for years. That is the main allegation. I have a relation with Sobita Das. It is admitted position that Sobita Das is already married. Now, Mr. Sobi, however, married to another man a couple of years back. Last portion, para 11. Lordship got it? Now, Lordship, para 13. Petitioner beg to state that since respondent is a police personnel, most of the time he needs to stay outside of his home. The brother of the respondent is also a police personnel, and therefore labeling any kind of allegation of affair with the brother-in-law of the petitioner of any kind of character assassination is not tenable. Petitioner's brother is a constable and he is in fire brigade. It is also page 18 now, page 55. Para 16, during time 2013, respondent preferred a case for seeking divorce at Gauhati, FC case number Iman. India 2014, petitioner preferred DV case number Iman, learned JMC. Hajo, petitioner wife begged to state a DV case. Had ordered that there was an order passed by the judicial magistrate class Hajo granting maintenance of rupees 4,000 per month to the petitioner and children. However, both the parties compromise. What I have already shown, Lordship, both the parties has compromised and the respondent had withdrawn FC case number Iman, and agreed party also withdrawn DV case number Iman, submitting a compromise petition 5/8/2016. Between the parties and according to joint compromise petition, respondent has agreed to pay 5,000 rupees per month, but after a few months, respondent stopped to pay maintenance to the petitioner. Though petitioner has tried his best to get close to the respondent husband in view of the above noted joint compromise petition, respondent was quite adamant is not have any conjugal relation with their petitioner wife. Respondent husband rejected, has been neglecting the petitioner wife. That is the allegation. They have also annexed the joint compromise petition as Annexure 1, page 56, which I have already shown. They have also annexed the illegal divorce case, compromise petition as Annexure 3. Lordship got it. So there is no dispute regarding the compromise divorce. Lordship, in January 2017, respondent stated, para 19, he will support the petitioner and their children financially as he, along with the villagers, forcefully has made a deed of divorce, forcefully, between the parties. Petitioner has forced to sign the illegal deed of divorce. At the time, whims of few villagers people at the whims of the respondent stated that the entire village is with him as there is a police personnel, no police station will register a case, her case against him. Further, he stated that he is close to the superior officer of the no affair against him will work. And further allegation is, Lordship, para 20, on 4/5/17, respondent husband married one Dipali Das illegally and divorcing the petitioner legally in a court of law, started their conjugal life at his own house. That is the allegation. I fairly submit, Lordship. One thing.
House means which own house? It is placed
No. Now, at his place,
as per their allegation.
Lordship. Allegation is
meaning
own house means there is a separate house because petitioner at the filing of this maintenance case, he is living separately in the house of the Utpal Das, which was constructed. So they are saying that I am living with Dipali Das and married with Dipali Das and staying with her in my own house. Dipali Das was a, Lordship, the nurse. I got a fracture injury of both leg. I am become crippled. There is none to look after me. My mother is about 85 years old person, 85-year-old lady. There is none to look after me and mother. I kept one Dipali Das to cook our food as well as to look after me, to give my food and everything. And their allegation is that Dipali Das was married to me. And thereafter, Lordship will find para 21. Just before the second illegal marriage of respondent husband, just before the second illegal marriage of respondent husband, he had thrown out the petitioner from his house. Before the second illegal marriage of the respondent, the three children of the parties had to take shelter at the house of brother-in-law. You've got it now, admitted. Brother-in-law, Deor, of the petitioner. Petitioner was still living in the house of the respondent. It is admitted position that still living in the house of the respondent. Now I will take your Lordship. The interim order of maintenance, page 66. Dated 28/6/2018. That is interim. So in view of the above, I do have a grant of interim maintenance at the rate of 5,500 per month with effect from today. That is 28/6/2018. Honorable Family Court granted maintenance of rupees 5,500. I was paying, but during COVID period, there is some error. Till date, some error is there regarding children's. Hereafter, Lordship, page 67. During proceeding of 125, I have deposited again 1 lakh rupees. Before the order, there is a compromise between the parties. There was no written agreement, but court has said you deposit 1 lakh and it will be over. Accordingly, I have paid rupees 1 lakh. Page 67. Lordship got it. Besides the other portion of giving maintenance, I have paid 1 lakh on 14/5/2025. Now, again, Lordship, the evidence, page 68 of Bobby Das at page 68. Page 68, same allegation that withdrawn the case when opposite party promised to keep me and pay maintenance rupees 5,000. Now, cross-examination part. I have not filed any case before the police station regarding physical torture. Cross-examination part. It is true that it is not a fact that I have illicit relationship with my brother-in-law, Utpal Das. It is true that opposite party had called a meeting in the village. It is not a fact that meeting was called to bring me back. It is not a fact that I did not appear in the divorce case and it was filed before the court. It is a fact that he constructed any wall separating me and Utpal Das on one side and opposite party and his mother on the other side. It is not a fact that I refused to stay with the opposite party. It is true that opposite party called Khelraj, that is a meeting. In the said meeting, opposite party put certain conditions which were not possible to follow and some allegations which were not true. It is true that in the meeting, my brother-in-law told that if opposite party, it is not true that if the meeting, my brother-in-law told that if opposite party divorced me, he would take me with him. It is not a fact. In the said meeting, I refused to go back with the opposite party and sign in the stamp paper. It is true that Sobita Das is now married. It is not a fact that I have given false allegations against the opposite party and Sobita Das. So this is the evidence during cross-examination. Her witness is herself and her daughter, page 70, Bobby Das. What you will find page 70, Bobby Das, Purobi Das, daughter. She is already married. Now, Lordship, the last portion. My father is stopped paying maintenance since 2017. He took signature of my mother as a consent of divorce. Page 70. In chief, she has stated. Last portion. My father is stopped paying maintenance since 2017. He took signature of my mother as a consent for divorce. He has admitted that there is my father has took this signature. Now page 74, let's say type copy. Page 74. You got it? My uncle Khura Utpal Das is doing service. Utpal Das is about 46 years. He is not married. I, my mother, my younger sister, and younger brother stay in the house of Utpal Das since 2014. Since 2014, it is admitted position that they are staying with Utpal Das. Present case has been filed in 2017, Lordship. They are staying with Utpal Das, my brother-in-law, since 2014. Khura loves me like his own daughter. Utpal Das is bearing all our expenditure, food and clothes, education fees, etc. The boundary wall between the house of my father and Khura, people cannot cross over it on the other side. I cannot say in which year there was a divorce petition between my father and mother. Why I am reading the evidence of DB case? This is relevant. Lordship will find I depose in the case, middle portion. I depose in the case which was filed by my mother at Hajo regarding domestic violence. And I depose in that case. In that case, I fully depose regarding the facts. Lordship got it. So I have read the proceeding of DB evidence only to substantiate this. And Lordship is aware, as per section 79 of the Evidence Act, when it is because proceeding under 125 is a summary proceeding, I can rely the evidence adduced by the parties in between the same parties in different proceedings. So, Lordship, it is admitted position that they are living separately since 2014. And they live with the brother of the petitioner. And Lordship can, may I take your Lordship again? They live since 2014 with their brother. And this divorce has been executed, mutual divorce, though it is not valid. It was executed on 21/1/2017, page 19. It was executed on 21/1/2017. Though it is not valid. 21/1/17, page 19, Lordship. Now it is admitted position that before this mutual compromise divorce, they are staying separately since 2014. That is the evidence of daughter of the petition, page 74. Now Kantiram has stated everything at page 76 regarding illicit relationship with his brother, page 76. I work in police post. I may not read lots, not relevant. I am work in police force. I married petitioner in 1997 as a social custom. I was staying with my brother Utpal Das and Bongshar, Abhayapur village. I was at Silchar for my employment. During the time my brother Bobby Das maintained illicit relationship with my own brother Utpal Das, I was staying with my wife at that time. I tried to sort out the matter, but my wife Bobby Das did not respond to my request to leave my brother Utpal Das and contributed her illicit relationship with my brother and also said that she will not stay with me anymore. After that, my brother Utpal Das requested me to forgive him and also said that he will not do the same matter in future. After that, I prepared an application for filing a divorce case against Bobby Das. Thereafter, my Bobby Das requested me not to file a divorce case. I agreed to reside with me. I did not file a divorce case. Later on, Bobby Das refused to come back into my society. Hence, I filed a divorce case, FC case number Iman, in the year 2013. During pendency of the said divorce case, Bobby Das filed DV case number Iman. After Bobby Das requested me to withdraw the divorce case, she agreed to stay with me with a condition that I will pay 5,000 per month as her maintenance. She also told me that if I withdraw the divorce case, she will withdraw the DV case pending before the judicial measure at Hajo. Accordingly, both the cases were withdrawn. Since then, I paid rupees 4,000 to Bobby Das. But when I went to the house of my brother Utpal Das to take Bobby Das, she refused to continue the conjugal life. Thereafter, I stopped making payment to Bobby Das. I called a male at our village. Accordingly, meeting was held on 21/1/17, and the male Bobby Das and myself executed Biba Bishet Nama by dissolving our marriage, and marriage is thereby dissolved. Exhibit A is the Biba Bishet Nama, proof in original. Exhibit A1, my signature. Exhibit A2 is the signature of Bobby Das. After executing the marriage dissolve agreement, I verbally made a complaint before the Gau Panchayat against Bobby Das and Utpal Das. Accordingly, when they called the Gau Panchayat on 25/1/17, they did not turn up. President of the Bongshar Gau Panchayat used to certificate on 25/1/17 with regard to the non-appearance of Bobby Das and Utpal Das. Exhibit proof is original. In the said certificate, when mother, member of the Panchayat, went to the house of Bobby Das to call her for the meeting, she admitted that she has been residing with my brother Utpal Das since 2013. Thereafter, Bobby Das filed a case. Exhibit C is the certificate copy of the withdrawn case number, FC case number Iman. Case has been withdrawn. Exhibit D is the certificate copy of the withdrawn order. Exhibit is the copy of the loan sanction letter. I have taken loans for my treatment. Exhibit F and Exhibit F1, FX are my medical documents regarding fracture injury. In an accident on 12/5/2010, my both leg got fractured, for which I did took treatment. And after that, the doctor advised me to consult psychiatric for sleeplessness. After the accident, I am still undergoing treatment under Dr. Jayanto Das. And I required 7,500 for my treatment in relation to the leg and brain. He became depressed also. So he was cross-examined, page 78 onwards. I am not reading all these things. You will find page 81 is a cross-examination, further cross-examination.
Yes.
Little portion, it is not a fact that none of the member of the Gau Panchayat has invited my wife Bobby Das into the meeting. It is not a fact that my wife Bobby Das never confessed that she is not living with my brother in the meeting. My brother is not staying with me. My mother is not staying with me at Gauhati. She is staying at Bongshar in my paternal property. It is not a fact that I am not taking care of my mother. A woman, namely Dipali Das, is there in their house since 2017. I do not know the name of father of Dipali Das, hailing from Holagaon or Chualkusi. None is staying with me save except Dipali Das, who is my caretaker. Dipali Das has been taken as a caretaker. I have filed a divorce case, but that have been withdrawn. Loan which was taken by me by the Exhibit E is the treatment of my fracture, and Bobby Das is not a beneficiary to it. It is not a fact that Bobby Das, my wife, is not maintaining illicit relation with my brother. It is not a fact that my mother is not maintained by me and keeping her in my house. It is not a fact that I have deposed falsely, save my skin. Now, Lordship, the evidence of village meeting, which is Lordship Ramesh Chandra Das, page 82. Para 2, Lordship. I know Kantiram Das, son of Deven Das, who is a resident of village Bongshor, Palkus in the district of Kamrup. Since Kantiram Das is a resident of same village, I personally know him since his childhood. Being a resident of the same village, we often meet each other, and Kantiram Das used to tell me about his day-to-day affairs and his family life. Now, Lordship will find page 83, relevant portion, para 7. Para 7 also. Presently, Kantiram Das is a constable in Assam Police. Because of the posting and duties allotted to him, Kantiram Das have to stay outside of his residence, keeping his wife, Bobby Das, along with his brother and brother Utpal Das. Taking advantage of this, Utpal Das, the brother of Kantiram Das, and Sri Bobby Das, wife of Kantiram Das, started making illicit relationship. As a result, news of the relation became known to all in the village, and Kantiram Das had to face lot of humiliation in the village. Kantiram Das also initially noticed the relation of his wife with Bobby Das and his brother Utpal Das from few years of his marriage, but ignored the same, considering that his wife may love him as his brother. Para 9, regarding meeting. In the same meeting, wife of Kantiram Das, Bobby Das, has openly declared in presence of the above noted person that she will not live with Kantiram Das as husband and wife. She will live as a wife of Utpal Das, who is the brother of Kantiram Das. Therefore, she has openly stayed with Utpal Das and brother of Sri Kantiram Das in the same residence, leaving Kantiram Das alone, and she has threatened that she will commit suicide if Kantiram Das and the villagers men force her to stay along with the Kantiram Das. And para 12, middle portion. Husband of Kantiram Das, and she will live with Utpal Das as husband and wife, who is brother of Sri Kantiram Das, and she think her brother, her husband. Kantiram Das has already died. Sorry, Kantiram Das has already died. According to her, Kantiram Das died. My petitioner has died. And Utpal Das, who is the brother of Kantiram Das, has also expressed in front of the villagers that he will keep the wife of his elder brother, Bobby Das, as his wife, and he will maintain the family. Wife of Kantiram Das, Sri Bobby Das, has also instructed the minor son and daughter not to talk with Kantiram Das and call him as a father. So, lot of humiliation petitioner has faced. Lordship, there is an important thing. Father of the petitioner has went to depose in favor of the petitioner before the family court. Lordship will find page 91. But it is surprise. I could not collect the evidence in SIF, but I could collect on the cross-examination part. Page 91 is the cross-examination part. Why it is not given to us, I do not know. Lords. Page 91. It's a Raju Bala Das, mother of the applicant. Cross-examination part. Lordship got it. It is not a fact that Kantiram Das was not maintained by Bobby because his general euphoria, because he never stayed at Bongshore. It is not a fact that Bobby Das does not have any love affairs with Utpal Das. These are the suggestions. At one point of time, I was staying with Bobby, Utpal and children begotten by the parties. I used to leave the society of Utpal Das and Bobby Das and family since I joined Kantiram Das at Gauhati. It is not a fact that I have deposed falsely before the court for favor of Kantiram Das only because I was intimated and threatened to assault unless I said so. it is not a fact that I stated is false and not at all false. So Kantiram Das mother and Utpal Das mother has deposed. That's my wife is living with Utpal Das. But I could not brought on record the evidence of Utpal Das. You can call the record also to see the evidence of Utpal Das. So finally, Lordship will find page 92, the order of granting maintenance. Lordship will find relevant portion at page 100. You got it? Opposite party is directed to pay monthly maintenance of rupees 6,000 to the petitioner's wife. I'm against this only. 2,000.
How has the magistrate family court dealt with the issue of 125 4?
No, nothing has been decided. Lordship, they ultimately petitioner's wife has been getting 6,000. 2,000 to Prohibitions still she married in 2023. She married Prohibitions, who has deposed before the family court, is already married in 2023. And 4,000 to Dolly Das till her marriage, and 2,000 to Son June Das till he attains majority with effect from date of filing of the case. So I'm not against the granting maintenance to my children. I'm not against that. I'm only against the wife. So in this particular case, I will place some judgment. I have made a compilation.
Next to your written statement. Right.
This statement has not been annexed. One thing will be relevant, Lordship. Mother of the petitioner has deposed before the hearing. I could not collect the certified copy of. Is the most reliable evidence because she is always in favor of their own son. Kantiram also, petitioner is also son, and Utpal Das is also son. Her evidence is a neutral evidence. And only the Bobby Das has given evidence of his daughter and Bobby Das, not any other witness. May I place the judgment also? Okay, 2001 1 GLT 368, para 5 and 7. You got it? 5.
Yes, not.
Is passed by Justice Jayan Sharma in 2020.
Chestnut Ranjan Nath versus Suklagrani Nath.
That's it. Case 3, para 5. Middle portion. The direct proof of adultery is not imperative. It would be unreasonable to expect direct evidence. As such, evidence, if brought before the court, must be suspect and apt to be disbelieved. The accepted rule, therefore, is the circumstantial evidence is all that can normally be expected to prove of the charge. What I have stated, what I have brought on record, is living with my brother. It's not possible for me to prove adultery. The consequence in this rule, it is not necessary to prove the fact of adultery in time and place, nor it is absolutely incumbent on the petitioner to prove, to identify of the person with whom the alleged act of adultery took place. Proof required to prove adultery need not necessarily be what is at the time said proof beyond shadow of doubt. It need not reach certainty, but must carry a high degree of probability. court does not, as a general rule, infer adultery from evidence of opportunity alone, but would require some more specific proof. Please, Lordship. Regarding adultery. There are 7, Lordship. Here is saying that adultery may be assumed when a man and woman is found in a dark room alone. As in such a case, there can be a presumption that they have gone there for prey. In view of the matter, learned statistics are rightly found a plea of adultery was not established. That case established was not established. Now, Lordship, next judgment, page 5. Chandra Saha versus Pratika Saha. Para 10 and 11. Page 8. The 9 last portion. Living together with a man by wife in the present case appears to be not a stray incident. Not a stray incident. What's it got it? Not a stray incident, nor a casual one, but having intention to continue living with another man as husband and wife, they took the rent in the house where they in fact started living together as husband and wife. Not a stray incident. It is admitted by their daughter that since 2014 they are living together in the house of their brother. Then now let's see the last portion of para 10. In my considered opinion, the inference required under section 125(4) of CRPC are fulfilled. It can be safely held that the wife started living together with another man as husband and wife with a definite intention to continue the same. In fact, they continued in living adultery from 28/6/2020 to 2000 till they were arrested on 6/7/20. Under the circumstances, I have left no option to alternative but to allow the revision petition. The learned session judge granting maintenance with the wife of the respondent hereby set aside. So, page 9, that is also Gauhati High Court judgment, Srimati Usha Das. That is the division bench judgment. There are 9 and 10. Page 10, Lordship. For the purpose of this act, desertion means intention, permanent forsaking, and abandonment of one spouse by another without other consent, withdrawal, reasonable cause. In other words, it is a kind of repudiation of the obligation of marital life. Statement of the appellant in her application for maintenance that no useful purpose will be served for continuing the marriage lends to credence to the fact that the appellant has deserted the respondent husband. That kind of leave separately for more than 2 years is there also since 2014 till date. The recent judgment, I Lordship, the Dishonorable Court 2005, 336, page 12.
Yes.
Para 26. Page 17. Please also seen that effort from the petitioner number 2. Other witnesses has given this statement wherein they have stated there is no torture meted out to the respondent number 2 by the petitioner when they many times petitioner along with other had gone to the house of respondent number 2 to bring her back to the matrimonial house for restarting conjugal life again, but same was rejected by the respondent number 2 the said occasion. In the context of the judgment, ultimately, para 27 in view of the aforesaid discussion, court observed the respondent number 2 is not entitled for any maintenance under section 125 CRP In view of the fact she had lived in matrimonial house without any sufficient cause. However, the order of the learned trial court by which maintenance was awarded to the minor daughter to the petitioner and same is maintained and petitioner is directed to pay maintenance to his minor daughter regularly. Same thing, Lordship. Now, Lordship, I will place a judgment regarding the other case where they have stated they have filed a petition at order of the family, the son, till attaining majority. They say the son is entitled to maintenance. They have relied a judgment of such effect. The Delhi has attained majority. But Lordship is aware, I will place a judgment on to that. Supreme Court has passed order of maintenance to the son. In case of an engineer, he has not get a job, but Supreme Court has get a maintenance. That power has been exercised under section. That power, Lordship is not a. I place a judgment. The other case placed by them, Lordship will find at page 18. Page 22. Page 22, Lordship, got it.
Yes. Page 34, para.
Last portion of para 10, Lordship. I'm not. At an application for grant of maintenance, therefore, is maintainable so far as the children are concerned, till they have not attained majority.
No, you are.
Para 10, page 22.
2.
Page 22, para 10. An application for grant of maintenance, therefore, is maintainable so far as the children are concerned, till they have attained a majority. As a cause of action for grant of maintenance would arise only in the event a person having sufficient means neglect or refuse to maintain his or illegitimate minor child, unable to maintain itself. Once therefore the children attain a majority, and said provision would cease to apply to their case. On attain majority, it ceased to apply because 125 clearly stated that till attain majority. If any person having sufficient means neglect or refuse to maintain his illegitimate child, not being married daughter, who has attained majority, where the child is by reason of physical or mental abnormality or injury unable to maintain itself. 25 clearly said till majority. And Lordship, this is not a petition under section 24 also. 24 of the Hindu Marriage Act, there is a provision for giving maintenance. So my submission will be, Lordship.
But your challenge in this petition is only to, as returning the wife, maintenance granted to the wife.
Other petition, I have an instruction to appear. I could not file the Ukalatnama because petitioner is in
It tagged with another, the other case.
Other case also tagged together. Other to a case they have prayed that son till his education. This is a humanitarian ground. As far as possible, if approached, I will give her education. This is my obligation. I have the duty. But 125 proceeding, there is no provision of granting. My humble submission, Lordship. And they have placed a judgment of Delhi High Court, relying a judgment of Delhi High Court, page 30, that is a judgment, Delhi High Court, which is not binding your Lordship. Where after attaining majority, Delhi High Court has given maintenance. That has been relied on, and at the argument stage, they have made this judgment as a point of argument. This is Delhi High Court judgment. So this is my humble submission before the Lordship, and I am Lordship. There are some area I have verified. Here are some area regarding maintenance to the children. Lordship, during COVID period,
I think you have left out one judgment. Case 26.
Page 26, Lordship. That is, Lordship, D.Y. Sundrasud and M. Saha. Completion of A's, Lordship. Case para 9. Para 9, why I'm stating, Lordship, the 142. Para 9. Para 9, last portion, Lordship. Hence, Lordship got it, hence. Hence, exercising our jurisdiction under Article 142 of the Constitution, we are inclined to pass an order in the interest of justice to envisage maintenance as reduced rate of rupees 10,000 per month and will be provided by the appellant to the respondent number 1 until he completes his first degree and course following upon the high school board examination. That exercise has been made under Article 142. That is why I'm placed the judgment. Supreme Court under 142, Supreme Court can any order. Sky is the limit as per Supreme Court itself. So my submission will be, if Lordship want to dispose this matter, I have no objection to that effect. And if Lordship want to take back the record from the appellate court, then also I have no objection. My submission to Lordship, I am against your wife that she is not entitled for maintenance. She is living separately since 2014. It is admitted position.
Just hear them. If necessary, we'll call.
Oblige, Lordship.
Please, Lordship. Two of the criminal revision petition 280-25. I can say there are two respondents, Lordship. This is a revisional jurisdiction of the Honorable High Court. I can see two respondents. One is Bobby Das and the other is Utpal Das. He was not a party in the trial court below. And otherwise, the petitioner husband has
So you are representing Bobby Das.
Bobby Das.
So you are not concerned with Utpal Das.
Lordship. Then I'm just pointing out because he was not a party and this is a revisional jurisdiction and the Utpal Das is made a party here. Otherwise, they had an ample opportunity before the trial court to call him as an official witness.
Anyway, notice has not been issued to him, has it?
That was issued, Lordship. Because,
Well, it is as good as non-existent.
At the initial stage, notice was not issued to Utpal Das.
Hmm?
The initial stage when notice was issued, Utpal Das was not issued notice.
Yes, I have seen that order.
now, Lordship, the admitted position is that marriage was solemnized in January 1997. 3 children born out of the wedlock, Lordship. These are the admitted position. Now, Lordship, if I come to the ground of adultery, the allegations being made, Lordship, against the respondent here in this Lordship, I'll page number page number 30, Lordship, the cross-examination part of that is being already read out, Lordship. But still, regarding the adultery, ground of adultery, Lordship, I have to read out. Lordship, the door, I am in the cross-examination part, Lordship, page 30. Lordship is there that.
Page?
I'm reading out from the cross-examination, Lordship.
Page.
Page 30, Lordship.
30.
Page 0. Lordship, my father and grandmother together cooked their meal in the side room. The door connecting our room with my father was closed by a sofa near the door. We are unable to open the door due to sofa. I do not know that a village meeting was held in our house over the relationship of mother and father. I do not know that in such meeting my mother stated that she will stay with my uncle. My father is working in police, and due to his work, he has to stay outside the house for many days. At that time, grandmother, uncle, mother used to stay in our house. All are staying together, Lordship. My uncle, my mother, my grandmother, even the children staying together in the same house. My father used to bear all the expenditure of a school and a house before the incident. I am unaware about the fact that property is divided between the father and uncle. My uncle constructed a house in the backside of a house near the main road. My uncle does not start to live there. My uncle is unmarried. I have not read the complaint petition filed by my mother in the court. It is not a fact that I have adduced evidence in the court detected by someone. It is not true that before filing the case, my father never argued with my mother. Rather, my mother used to argue with my father. All the villagers know that my mother stay with my uncle. My father stated the fact before everyone, because all the villagers know the mother stay with my uncle. This fact was stated by my father to the villagers. It is not that mother is staying with the uncle. The father stated before the villager. That is why the villagers came to know about it. I and my brother now stop our father to treat him as father. I'm coming down 3 lines down. I do not know the fact that since 2015, the marriage of Sobita was held in Hangrabari. I know the fact that Sobita is our relative. I visit my relative house. My father used to love my sister and brother. He never loves me. Now, Lordship, I'd like to read out from the page 53 and 54. Page 53, paragraph 10, Lordship. Paragraph 10, that the respondent husband, by profession works in Assam Police, and as such, most of the time, he has to stay outside his house and has been neglecting the petitioner wife and their children for a long time. The petitioner requested the respondent to take her to his place of posting, but his request has landed in deaf ears. It has been argued that because he is a constable, he cannot take his children. Otherwise, I have seen that even the constables, they're taking their children and the wife to the place of posting and the studying in that respective place, Lordship. Now, Lordship, I'd like to take it to page number. Page number 78, Lordship, which was not read out by the petitioner, Lordship. I'll read out from the cross part of it, Lordship. Page 78, Lordship.
70.
78.
78.
78. Lordship, cross part I'll read out. The divorce case was withdrawn in the year 2016. I do not remember the exact date on which the divorce case was withdrawn. We mutually divided our personal property and constructed the middle wall of our respective share on request of my brother. I do not remember in which year I constructed the middle wall. So he constructed. It is not that the brother constructed. He constructed the wall. I do not remember whether.
78, which line?
The cross part, Lordship, in the paragraph, the second paragraph, Lordship, there.
This case was withdrawn in 16.
Yes, Lordship. I'll read out again, Lordship. The divorce case was withdrawn in the year 2016. I do not remember the exact date on which the divorce case was withdrawn. We mutually divided our paternal property and I constructed the middle wall of our respective share on request of my brother. I do not remember in which year I constructed the middle wall. I do not remember whether the middle wall was constructed prior to withdrawal of the divorce case. I am staying in rented house at Kahelipara, Gauhati. To look after me, I have kept one woman, Dipali Das, since last part of 2017. She started staying with me since I was at Bonghar and later on shifted to me to my rented house at shifted with me to my rented house at Gauhati. She came to my house with a daughter, namely Bismita Das. I do not know who is the father of the said daughter. I do not know. I have not seen the birth certificate of the child. I look after my mother who is staying at Bongshar. I am paying electricity bill of the house of Bongshar, but to prove the same, I have not submitted any electricity bill. My mother is staying alone at Bongshar. It is not a fact that I married Dipali Das and I am the father of Bismita Das. Now, Lordship, why these were put to he was put to question during cross-examination? I look up to my mother who is staying at Bongshar. So it is an admitted fact that the mother is not staying with him at Guwahati. The mother is staying in Bongshar along with his wife and his own brother and the children. They're staying together in Bongshar in the same house, Lords. So I look after my mother who is staying at Bongshar. I am paying electricity bill of the house of Bongshar, but to prove the same, I have not submitted any electricity bill. My mother is staying at Bongshar. It is not a fact that I married Dipali Das. Now, Lordship, this is somewhat. I'll come to the how he's being an adulterous relationship. I'll come to that step by step, Lordship. Here is how he has at least admitted that he started, that he took to look after him to me. I kept one woman, namely Dipali Das, since last part of 2000. That is an admitted position, and there is a daughter he disclaimed to be her father. Now, Lordship, I'll come to page 9. Now, Lordship, at page 89. Page 89, cross of DW2. If Lordship, that page, Lordship. Page 89.
Yes.
Yes, Lordship. I start from I was present in Gauhati. I was present in Gauhati on 21/12/2020.
Who is this person? Ramesh
This is
Chandra
the-
Das?
This is the witness of the husband.
He was the village man, first attended the village meeting when, and he was the president of a Amghar.
I'll read out. I was present in Gauhati on 21/12/2022. Know the name of the woman which is kept by Kantiram Das in his house. This is capped, Lordship. The quote unquote were capped. Both Kantiram and the capped woman, again repeatedly, Kantiram and the capped woman, Lordship, are staying in Gauhati. They have got a daughter born out of their living together. Lordship, I'd like to take you to page number 83. That is the examination in chief of the file in the manner of at page 80, paragraph 6, Lordship. 83. That presently, Sri Kantiram Das is living in his residence along with his old mother. at the time of marriage between the Sri Kantiram Das with Srimati Bobby Das, Sri Utpal Das, who is the brother of Kantiram Das, was his high school student. That is how the suspect level is. At the time of marriage, he was reading in the high school, and the suspect to what extent. I will come to the in the judgment. These are being observed, Lordship. I'll read out how these are being observed in the judgment, Lordship. Then, Lordship, at also at page 90, where there is a allegation that the wife pretend to commit suicide. That is a statement again made by this village man, the president of Pangshi Gopal Namgar or so. Now, Lordship, I'm reading from page number 90, where it is written that I have not filed any complaint against the petitioner because he was aware of the threatening to suicide, which was an allegation only. I have not filed any complaint against the petitioner for her threatening to commit suicide. If Lordship can see that at page. Kantiram also has not filed any FIR alleging that Bobby threatened to commit suicide. So allegations proved to be wrong, Lordship.
What FIR would be anybody lodge if somebody threatens to commit suicide?
Since threatening to commit suicide, that can obviously be. Otherwise, the husband will be living in under threatening conditions. And if something happens in his house, that will go against him, Lord. Lordship, now page 91, that is the cross-examination part of the mother, that is DW. At one point of time, I was staying with Bobby, Utpal, and the children begotten by the parties. I used to leave the society of the Utpal Das, Bobby Das, and family since I joined Kantiram at Gauhati. So at one,
Reading?
Lordship,
Where are you reading?
I'm reading from page 91, Lordship. That is the cross-examination of mother of the the middle portion of the second paragraph, Lordship. At one point of time, I was staying with Bobby, Utpal, and the children begotten by the parties. They're staying together, and there are allegations of adultery, Lordship. Mother was staying there. I used to leave the society of the Utpal Das, Bobby Das, and the family since I joined Kantiram at Gauhati. So she left the company of Utpal Das, Bobby Das, and the family since I joined the Kantiram at Gauhati. And I have the different suggestions during the cross examination that because of because she is being influenced by the Kantiram Das, that is the husband. She left the company of the respondent, the wife, and started living with the Kantiram at Guwahati. But as I have already read out, that Kantiram Das already I have read out his portion, his portion of cross examination, that mother is staying at Bangshar, he is paying the electricity bill. That will substantiate the claim that that maybe for some time she was living with Kantiram, the husband, Lordship. Lordship, at page 10, Lordship now. Page 10, that petition, Lordship, as per paragraph 14, Lord. paragraph 14, that the petitioner begs to submit that on 12/5/2020, petitioner met an accident and both his legs have been fractured and there was no one to look after. These documents are not part of the record here before the Honorable. As a result, a nurse was appointed and her name was Dipali Das, as petitioner's mother is old as a lady and about more than 80 years old. The word nurse, Lordship, the quote unquote word nurse, this is for first time. This is not with the trial court below. It is already, he has kept someone. He has kept someone with him in Guwahati, and before that, he has kept someone. This that Dipali Das in his village house, Lordship. He shifted to Guwahati to a rented house. That lady is also being taken with him. And this nurse word is very in a, like afterthought of the petitioner to use this word nurse.
But assuming that is true,
Lordship.
is his conduct the question here now? About the husband, about lady carrying her or begetting. That the issue now is about your conduct, living in adultery or deserting. The issue.
That is what I am
125 does not mention about the conduct of the husband.
First, Lordship, what happened actually? 2014 is the year when I was thrown out of the house, and 2013 is the year when my husband filed a divorce case. I was thrown out, and since 2013-14, he was engaged with different ladies, and this lady is staying with him for a long time in the village, and then shifted to Guwahati. And that is being substantiated. My claim that he's living in adultery, that I have substantiated with the cross of DW2, that and that lady is a capped, not the nurse.
But do we get the time from whence?
Lordship, Lordship, at page 78. Page 78, cross part that I have already read out. To look after me, I kept one woman, namely Dipali Das, since last part of 2017. That is the cross-examination of PW1, my husband.
But you left sometime in 2014.
14, Lordship.
Before Dipali Das entered the picture.
Lordship, what happened 2013, my husband filed a divorce case because it will be against him. If I stay with him, I was thrown out. In the year 2014, I was thrown out. And then in the year 2014, I filed a domestic violence case. Lordship. Now, Lordship, at page.
Okay, we'll continue. Yes. I think we were on page 78.
Lordship. Lordship, a question was posed to me that why the husband's character should be in picture. That I'll come. why it is important as per provisions of law. Before that, Lordship, what is admitted here is that the husband preferred one divorce application in the year 2013. 2014, the wife along with the children were thrown out, and then along with the children, the wife started staying in the brother-in-law's house, the brother of the instant petitioner's house, and also along with the mother of the petitioner, Lordship. Now, Lordship, at page 68 of the petition, criminal revision petition 280 at page 68, Lordship. Page 68 is the evidence of the PW1. I'll read out, Lordship, from the second paragraph. I came to know that my husband was having an affair with one Sabita Das. I asked him several times to mend his ways. It was then that the second party started torturing me physically. When I started to mend his ways, the second party started giving false allegations that I was having an affair with my brother-in-law. Thereafter, the opposite party filed a divorce case in this court. I have also filed the domestic violence case before the Haju. I withdraw the case when the opposite party promised to keep me and pay maintenance at the rate of rupees 5,000 per month. Although he paid for 3 months and thereafter stopped paying, he started a new affair with a girl, one Dipali Das, and married her. He also has a daughter out of the marriage. The second party withdrew the divorce case filed by him. I have no income. The second party is working in Assam Police Department as Mali and gets salary of rupees 45,000 per month. I have to maintain 3 children. Therefore, I seek maintenance at the rate of rupees 20,000 per month. My eldest daughter is doing her graduation in PEB. The second one is in class 10, and my son is in class 8. Now, this is important part, Lordship, the cross-examination part. I have not filed any case before the police station regarding the physical torture, although I have preferred the domestic violence case, Lordship. It is not a fact that I have illicit relationship with my brother-in-law, Utpal Das. It is true that the opposite party had called a meeting in the village. Now, this is important, Lordship. Why the agreement between the parties, the forced signature taken, that is a first agreement. Why it is? The suggestion given now, an answer to that is, it is not a fact that the meeting were called for bringing me back. That was the suggestion. But the contention of the husband is that it was for the divorce case, signing the divorce agreement. It's a farce, Lordship. From the suggestion itself, it appears, Lordship. Now, Lordship, going further, it is not a fact that I did not appear in the divorce case that was filed before the court. It is not a fact that he constructed any wall separating me and Utpal Das on one side and the opposite party and his mother on the other side. It is not a fact that I refused to stay with the opposite party. It is true that the opposite party called for Khel rise. It is in the said meeting, the opposite party put certain conditions were not possible to follow and some conditions which were not true. It is not a fact that in the meeting, my brother-in-law told that if the opposite party divorced me, he would take me with him. It is not a fact that in the said meeting, I refused to go back with the opposite party and signed in a stamp paper. It is true that Sobita is now married. Now, Lordship, here in the entire cross-examination, I do not find one thing putting any question or giving any suggestion to that effect. The statement to the statement, although he started a new affair with one girl, Dipali, and married her. That effect, no question was put in the cross-examination and no suggestion was given during cross-examination. That will sustain along with how it is substantiated by the cross-examination of the DW, the witness of the petitioner husband, lordship.
Pita, another is Dipali.
Dipali. Sabita, with whom my allegation is that with Sabita, see, he was with since 2013. Then Sabita got married later on, and since 2017, as admitted by the petitioner husband, they had been staying together. Lordship. Lordship, I have read out the relevant portion as page 78, how he has stated that to look after me, I have kept one woman, namely Dipali Das, since last part of 2017. That is being reiterated by him again during cross-examination, that is as page 81, Lordship. He stated, a woman, namely Dipali Das, again, Lordship, he stated, reiterating, is there in my house since 2017. I do not know the name of the father of the said Dipali Das, hailing from Halugao near Palkusi. None is staying with me. This is important. None is staying with me, save and except Dipali Das, who is my caretaker. He stays with a lady. Now, Lordship, I'd like to take you to page number 75. Page number 75, Lordship. The petitioner husband, Lordship, has been trying to prove that she is in an adulterous relationship, which they have been, the petitioner is failed, even with his own witnesses, even his own witnesses confesses that he is having a kept. I will come to that, why that is important, the character of the husband petitioner, why it is important. Page 75 is important. A suggestion is given to the daughter of the petitioner, to which she has replied, it is not a fact that my mother and Khura live like a husband and wife. They could not, to prove an adultery, there should be some kind of an evidence, Lordship. Then, Lordship, what my contention is that we as a family, I, along with my children and also my mother-in-law and my brother-in-law, we are staying together as a family, Lord. It is not a fact that our Aita stays with my father. Aita is not staying with the father, Aita is staying with him. That is my contention being throughout, Lordship. Now, Lordship, Section 125, Lordship has pointed out whether is there anything in the judgment regarding Section 125 subclause 4, Lordship. But before that, there is an explanation, Lordship, why husband's character is important. The explanation reads here, Lordship, if a husband has contracted marriage with another woman or keeps a mistress, it shall be considered to be just ground for wife's refusal to live with. That explanation, Lord. That is why husband character.
That part is okay, but
that, so,
living,
and in our
despite
case,
that, if
Lordship.
the adultery is proved, would that come to your aid?
Lordship.
That is regarding desertion.
Lordship.
The question of adultery by the wife, living in adultery, if that is proof, then would that provision come to your aid?
And that obviously will not come. How the adultery is proved, Lordship? I'm still.
No. We are not saying it is proved,
Lordship.
because that is the contention.
Lordship.
So to address that, that is what I'm saying.
Lordship. Now, Lordship, findings in the judgment, I'll come to that now. Page number 97, Lordship. What is the finding, Lordship? Page 97, paragraph 8. Exhibit A relates dissolution of marriage between the parties outside the court, which has no legal value in the eye of law, as because no marriage between two Hindus can be dissolved in a public meeting. The allegation of extramarital affairs between the petitioner and Utpal Das has not been proved, as there is no direct or indirect evidence on this issue from the side of the opposite party. A mere allegation of wife's extramarital allegation or proof of maintaining a dependent wife by someone does not disentitle the wife from maintenance from an able-bodied husband. Admittedly, since 2017, the opposite party has been keeping one Dipali Das with her daughter with him as his caretaker. The explanation in section 125.3 CRPC 1973 is of a is if a husband has contracted marriage with another woman or keeps a mistress shall be considered to be just ground for his wife's refusal to live with him. Paragraph number 9, the DW3 is the mother of the opposite party. The opposite party, that is DW1. In her evidence, she complains that she has been maintained by her son Utpal Das, as he has grievance against her son Utpal Das. Therefore, her evidence cannot be considered to be determining factor in this case. The petitioner is claiming monthly maintenance from the date of filing, that is 28/8/2017, with the ground that she, along with her 3 children, have been neglected by the petitioner, who is Assam government servant and salary is more than 45,000, besides having landed property located at different places, that the petitioner also defaulted the other order of maintenance in DV case number 16/2014, and the area amount accumulated to rupees 55,000 by filing this case under section 125 CRPC. So having that read out, Lordship, this is what is being the finding of the trial court, Lordship. Lordship, is it? Lordship, I am relying upon few judgments, 3 judgments of the Honorable Supreme Court regarding the revisional jurisdiction of this Honorable Court. Is a 2007 judgment, Lordship. I'll be reading out from. This is Paila Muttalama versus Paila Suri Demuru. In 11, 12. First of all, I'll read out from paragraph. I'll read out the paragraph 9 and 10, Lordship. That is at page 4 of the judgment. In fact, we also find sufficient substance in the plea that the High Court, in its revisional jurisdiction, ought not to have entered. Ought not to have entered into the scrutiny of finding recorded by the magistrate that the appellant was a married wife of the respondent before allowing an application determining maintenance, and it is well settled that the revisional court can interfere only if there is any illegality in the order or there is any material illegality in the procedure, Lordship, and or there is an error of jurisdiction. The High Court, under its revisional jurisdiction, is not required to enter into reappreciation of evidence recorded in the order granting maintenance. At the most, it could correct a patent error of jurisdiction. It has been laid down in a series of decisions, including Suresh Mandal versus State of Jharkhand, AIR 2006, that in a case where the learned magistrate has granted maintenance holding that the wife has been neglected and the wife was entitled to maintenance, the scope of interference by the revisional court is very limited. The revisional court could not substitute its own finding and upset the maintenance order recorded by the magistrate. At paragraph 10, I am reading out, Lordship. The revision against the maintenance order passed in the proceeding under section 125 CRPC, the revisional court has no power to reassess evidence and substitute its own findings. Under revisional jurisdiction, the question whether the appellant is a married wife, the children are legitimate, illegitimately being preeminently question of fact cannot be reopened. The revisional court cannot substitute its views. The High Court, therefore, is not required in revision to interfere with the positive finding in favor of the marriage and patronage of a child. But where finding is a negative one, the High Court could entertain the revision, reevaluate the evidence and come to a conclusion whether the findings or conclusions reached by the magistrate by legally substantiable or not as a negative finding. This negative finding, Lordship, that is quote unquote, Lordship, has evil consequences on the life of the both child and the woman. Then, Lordship, towards the end, thus the ratio decidendi which emerges out of a katana of authorities on the efficacy of judgment of criminal procedure is that it should not be disturbed while exercising revisional jurisdiction. That is one finding of the Supreme Court in India. Then, Lordship, I am relying upon the Karnataka judgment that is also which is relied at page 5, Lordship. The court in exercise of power under section 397 of CRPC cannot reappreciate the evidence and arrive at a different conclusion, even if different view is possible from the evidence. The jurisdiction under section 397 CRPC could be exercised only when the decision under challenge is found grossly erroneous, non-compliance with the provisions of law, the findings of fact affecting the decision is not based on evidence, non-consideration of material evidence. This is important, laws. Non-consideration of material evidence, whether what was being submitted by the petitioner husband before the trial court below, whether any of those things were not considered. That the witnesses say that she is living in adultery, that the wife said that he is living in adultery or he is living with someone. All those things were being considered, Lordship. So non-considered material evidence, only then this court has the power to do that. And that the lower court has exercised the direction arbitrarily and perversely and acted in excess of its jurisdiction or abused its power, resulting in failure of justice. No errors or irregularities are found in the impugned order. The last one I'm relying upon is that the Supreme Court India judgment again. Also, it is of 2003 at page 20, Lordship. Question at page 20. Page 20, Lordship. Yes. We therefore hold that the High Court was not justified in setting aside the findings recorded by the learned judicial magistrate. We have reached the conclusion after appreciating the evidence on record, since there is no discussion of the evidence in the judgment of the High Court. So if there is at all no discussion, only then the High Court will enter into those facts, material facts, Lordship. Now, Lordship, this is all about the where I have submitted before this court that event through the DW evidences, that is the witness who has said there is the husband has a capped, so he is in a relationship with another lady. That has been proved, Lordship. And when the provision of the 125 CRPC states, if a husband has contracted marriage with another woman and keeps a mistress, Lordship, what do I need more to prove that he is keeping a mistress? And what do I prove? What do I prove more? Even with the daughter stated that my mother and my uncle Khura is not in a husband-wife relationship. What do I prove more, Lordship? Even by the statements of the petitioner husband, that that my wife, my brother, along and my children, and also the mother, that is being proved by the witness of the daughter, my daughter, that the my brother, even the mother is staying with them. What do I prove more to disprove the allegations of adultery out of all these Lordship? That is why the petition preferred by the petitioner husband should be rejected. Now, Lordship, what was the grounds in his petition, Lordship? Let me go through the grounds. If I read the ground, Lordship, ground at paragraph at page 11, paragraph 2, Lordship. For that, one of the daughter, Purobi Das, is already married in the year 2023. Thus, has already crossed the age of 18 years. As such, there is no question of granting maintenance to them. So, from here, it appears that the second daughter, who is still unmarried and studying, he doesn't have any objection to pay maintenance to his second daughter. Now, Purobi Das also, the petitioner husband doesn't have an objection, who married in the year 2023. Till then, from the date of filing, till then, he doesn't have any objection to pay maintenance to the eldest daughter. Now, Jundas, who has crossed the age of 18 years, till 18 years, he doesn't have any objection. Now, with the judgments, as rightly pointed out by
And till the time of marriage and till the date of attainment of majority, he has no objection.
no objection. And the second daughter also no objection. Now, the petitioner husband has objection to pay maintenance to his wife on the ground of adultery, which I hope I am able to satisfy this honorable court to disprove the grounds of adultery, Lordship. Now, Lordship, this is the Supreme Court of India judgment, which was rightly cited by the petitioner husband, obviously after my citations I have given in my petition, Lordship. Now, this talks about we have the Juktavat Devi judgment of the Honorable Supreme Court, wherein it is stated that the girl will be a girl is entitled to maintenance till she is not dependent. That is the wording of that judgment. So he doesn't have any problem with that. Now at page 4 of the judgment, at paragraph 4, I am reading out. This is Supreme Court of India judgment, Lordship, Chandra Shekhar versus Sapnil and others. Para, Lordship, at para 10, para 4, at page 4, Lordship, last page, Lordship. The appellant shall pay in maintenance for the first respondent on the above basis for a period of 6 years, commencing from 1st April 2021 until 31st March 2027, or until the first respondent completes his first degree course, whichever is earlier. The direction is intended to ensure that the first respondent shall be maintained by the appellant until he completes his basic education, ending with a first degree course after he completes his high school education. And this ruling is being followed by the Delhi High Court. Almost in the same year, Lordship, the Supreme Court of India judgment was on 4/3/2021, and the Delhi High judgment ruling came on 14/6/2021. That is in the same year. So I'll be reading out, Lordship, Paragraph 12 at page 6, Lordship. I'll be reading it out towards the middle of it. If Lordship can state, it cannot be said that the obligation of a father would come to an end in the middle portion of paragraph 12, Lordship. It cannot be said that if Lordship is in that, in the
Yes.
in the middle part, Lordship. It cannot be said that the obligation of a father would come to an end when his son reaches 18 years of age, and the entire burden of his education and other expenses would fall only on the mother. The amount earned by the mother has to be spent on her and her children without any contribution by the father, because the son has attained majority. The court cannot shut its eyes to the rising cost of living. Then bit below, Lordship, this court is therefore inclined to grant a sum of rupees 15,000 per month as interim maintenance to the petitioner number 1 from the date of the date of petitioner number 2 attaining the age of majority till completes his graduation or starts earning, whichever is earlier. This is what is relied upon by the Delhi High Court, Lordship. So under with these submissions, Lordship, I rest my case, Lordship, and
Your answer to the contention of the other side that the Supreme Court can grant this relief in view of Article 142. Has no power to do so.
at the fact, Lordship, we have seen that Delhi High Court has already followed. Delhi High Court has already followed it, Lord. It's in the same line. Lordship.
Delhi High Court has not said under what power it has.
But it is in the similar line, and also that Delhi the Supreme Court judgment precedes the Delhi High Court judgment, Lordship. One 42 is okay, but Lordship, why not we can the ratio can be followed here and the new High Court, Lordship. And this is a welfare legislation, Lordship, for the child. Welfare legislation, Lordship. That will be my submission before this court. Welfare legislation for the children, and at this tender is when he is pursuing, and I have annexed in the other Lordship. I have submitted all his educational certificates and all the my admission receipts, Lordship. At this tender is, if the maintenance is cut down, then he will not be able to stand on his feet, Lordship.
You're absolutely right on that point, and that is past that order that 18 years of age, he would be at best what pass the background. It is on the background also.
That is why completes graduation or starts early, whichever is earlier. That is the
Going for higher studies anyway. Kept in mind anyway. Other cases, basically submissions are same. The other one,
the other cases I have filed only for the son, Lordship.
enhancement.
Not enhancement. Payment of maintenance after. Only for that reason I have preferred that.
Is
That is revision number.
we'll reserve the judgment, but Yes, it is felt the records are necessary. Spoken to. Maybe.
Okay, I will place a judgment of court today, master regarding power of revisional court. Judgment is established that when culpable error committed by the trial court, revisional court has a jurisdiction. Obliged.
Lordship,
Lordship.
yes, submit. Because there is an area of rupees around
already
6
admitted.
lakhs, Lordship. 6 lakhs, that is not being paid. And that 6 lakhs is for the children.
For final decision now,
Lordship. Obliged.
time of reserving, any passing.
Obliged. Interim order to continue till disposal. Obliged.
Eight. Passing of an order dated 2/9/2025. Order. By the earlier order, notice was issued. Of the prayer on the returnable date. The order is at page 50. FIR
I think on the another clear occasion, some leave raised by the prosecution that the government has not been made a party. What about that? Is it necessary? It is recorded in the order.
basically a GR case. And the POCSO. Twenty-eight is the order, my lord, which only on the legal proposition. So the cognizance has been taken under section 196 to 29. Whereas 17 NSS is concerned. It requests prior sanction for taking cognizance. First, the offense under section 190. Here apparently there is no sanction. Page number 26, column 15, whether prosecution sanction. The charge sheet also doesn't say what sanction has been obtained. Are of taking cognizance. An aspect of the matter, find in the page 28. They said there is a seizure, have searched and seized
Yes, sanction is required in respect of which offense?
Section 196 and 299. Required by section 217.
170.
217, my lord, PNSS.
Where do we find 196(2) in 17 BNSS?
17, prosecution for offense against state and for criminal conspiracy. Court shall take cognizance of punishable under chapter 7 or under section 190
196 and 299, both are there.
or subsection 1 of
Yes, prosecution.
Provisions added at the law. L, my lord. It is on the basis of that, my lord, a
Says no court shall take cognizance. Section says
condition.
it is there, ma'am, because even at that is also, my lord, that hence, my lord, a sanction can be ordered and it is done, my lord. Also, my lord, either way, my lord. That, my lord, in my humble submit,
checked.
otherwise, my lord, urge the, my lord,
We will examine them, but we have to stay the proceedings. The learned counsel for the. It is. Petitioner that. By the. Prior sanction has been. Further proceedings in so and so is hereby stayed.
chair is received, my lord.
This here. Give a date.
Obliged. Obliged.
CD received.
Is received, my lord. After tomorrow. Friday, my lord.
Have it on Thursday, day after tomorrow. Learned counsel for the petition. For the petitioner and learned additional.
Okay, here an application is filed under section 4.
Just a moment. Yes.
My case is already appointed, my senior is. My lordship, my lordship, I take your lordship, my lordship would be pleased to.
What is the IA for?
IA is for the suspension of the sentence and for the release of is behind the bar, my lord, appellant.
The sentence.
A sentence is, my lordship, 7 years, under section 4 of the POCSO Act, he is convicted to rigorous imprisonment for 7 years and to pay a fine of rupees 7,000. And he has been behind the bar, your lordship, the passing of the judgment on 5/8/2020.
Who has already been represented.
Yes, my senior is already there, amicus is appointed.
Filed by prosecution.
Here in this judgment, your lordship, first. You know, but the most count is page 27 if of the judgment, my lord. Page 27 of the judgment, what happened was that in the cross, she has stated, actually 164, she has stated evidence completely different. A question was put up in cross and she has replied, it is not a fact that what I have stated in 164 statement was tutored by the family of the accused. Which the Honorable Sessions Court, Special Judge Court, Your Honor, has recorded it in a different manner in page 27 and she proceeded with that point only. Your Honor, for a second, I take your lordship to, Your Honor, Your Honor, for a second, Your Honor, peruse page 63, the 164 statement.
In the appeal.
Appeal. In the appeal, I have in the appeal.
Yes.
The incident took place on 9/6/2017 at around 9:17 p.m. On the day, as my mother was telling me something related to studies.
Don't read on.
On the day as my mother was telling me something related to studies as I have obtained low marks in the exams. At night during study time, I called my elder brother's friend, namely Vishnu Dotto, he's the accused, near to my home secretly. There was love affair between me and Vishnu Dotto. After Vishnu Dotto came, when I heard the horn of the bike, I came outside from the house and told Vishnu
to drop me at a little distance. After sitting at the bike, I told him that I am feeling frustrated by staying at home and to take me somewhere. He then took me towards Dhemaji side on the same night and called one of his friends from Dhemaji. But as his friend was not at his home, so we stayed at Lilabari at one of his friends named Partho's house. There I stayed for 2 nights. I slept with the wife of Partho. No bad thing happened with me. Later on, I realized that I did mistake. Therefore, I phone call at my house and by getting in a car, went home. I went on my own consent. I have this much to say. Your Honor, in the 164 statement, the occurrence took place on 9/6/2007. As per the 164 statement, she was on 2 nights, she was in the along with the wife of Partho, and she was sleeping with wife of Partho. This wife of Partho is not made prosecution witness, and it stated that she herself called her family members and thereafter she went back. Your Honor, please, I take your lordship to forest PW1, the position of PW1, page 49. Three.
Yes, go.
The evidence, if I know the accused Sri Vishnu Dotto, who is the friend of my elder brother Sri Rakesh Singh. The occurrence had take place 1 year back. On the day of occurrence, my quarrel had picked up with my mother, Srimati Basanti Das. Then I came out from the house and stood by the side of the front gate of my house. At that time, I saw the accused Sri Vishnu Dotto was going by a motorcycle. On seeing him, the accused Vishnu Dotto asked me what had happened. I stated that my quarrel had picked up with my mother. Then the accused Vishnu Dotto asked me to sit in his motorcycle and told me that he would take me to the house of his aunt situated at Sinatolia so that I might come down. Then I got into his motorcycle and the accused Vishnu Dotto house of his aunt situated at Sinatolia. In the house of his aunt, I stayed 1 night, and on that night I slept with the accused on the same bed, and the accused had performed sexual intercourse. On the following day,
Sir of right leg to both.
Right and left wing. If I will take some time over the other hands. Seven is the MO minor. PW7 is the MO minor. Also, given minor, such type of injury may be caused by falling from bike. Crossman, others.
How old is the appellant now?
Like both were intoxicated actually, what evidence it has come, and there were a collision on the road. Yeah, but contradictions.
Part minor, they said that yes, there is a collision. That part is accepted, but the DW said that the injury that has occurred is not because of the and the eyewitnesses are there. 4 or 5 eyewitnesses are there. They have supported that. They have
None of
seen
the evidence, they have come
assaulting-
afterward the incident minor.
assaulting the
Yes.
minor.
Because they could not exactly say because there were contradictions a lot of between them. One with eyewitness said that in the chief he said that the right leg was injured, broken, and the cross said left leg was minor. In the chief said the victim came on foot, and in cross said that the victim was coming on cycle. But this kind of some contradictions are there, my lord. The only thing is that since a long pending case, my lord, there are judgments. Cases, my lord, the court should. Right, my lord.
Incident is of the year.
My lord, incident is 2002, my lord. It's a bit of
2002.
17/11/2002, that's how. Both were intoxicated, my lord. That is there, my lord.
I think in these facts and circumstances, we can apply the provisions of the hard learned comes.
Yes, revision
This is a revision.
petition.
Fine. By which the IYPC, fine of rupees 1,000. ID. Yes. There is the evidence on hard fracture of his second para PW 6. That the court that the occurrence of the if the benefit extended. Learned appellate. IPC. Part of the order
I'll
I'll
vote it
pass
fine.
later. Yes, yes. Set aside that, then provisional does not come in anyway.
That is why.
POCSO Act, therefore an amicus be appointed to represent respondent number 2 and
The petitioner then, since the case is under act and amicus present the respondent number 2. Or unserved notice. Respondent number 2.
Transfer can be.
I'm on behalf of the
in this criminal that petition might
Number two also no.
but my
Service is complete. Case is under what section?
my lord, this criminal revision petition against the
Offense involved. Third learned counsel for the petitioner.
yes, legal aid counsel, my lord.
Learned legal aid counsel for the petitioner.
My lord.
One appears. The husband, so we need not appoint amicus if it does not appear.
Husband and wife, my lord.
Call for the thereafter. Explanation is disposed of.
My lord. Yes, my lord. Condemnation petition disposed of, my lord. Obliged.
There is a washing petition, my lord. Of course, is the NDP for washing of the affair and charge sheet, my lord. I take a lot. I don't think we will have time to hear the entire matter today. Next week. Okay. So 25, okay, no urgency. After 2 weeks. That may pray, date may be given. Give a date. Bill, get a date.